Oh, stuck. Just taking a walk through the paperwork for her first trial. Figure I might as well just do it publicly. one, I believe. Yeah. Welcome, welcome, welcome to me, myself, and I. This is just a walkthrough of this new little set I designed and me getting ready for this case coming up. And I'm really interested in this case with Takia Bevily, and I'm more interested in the the dynamic because very rarely do we have a case where all of the main actors are black. So it's out of a single culture that we have all of the major pieces, and so we can actually talk about the law. We can talk about the process. We can talk about, you know, just what's going on, and we don't have to get bogged down with the race, because race takes it somewhere else. Even though there are still some racial elements to this, a couple of the main actors are actually not African American, but the fact that the district attorney is an African American woman, the judge is an African American woman, the prosecutor is African American. I mean, the prosecutor, the ADA is African American. I think it's a couple of men, and I think that team is multicultural. But the all the major players involved in this are African American, and there's even what looks like two different class levels of African Americans in this same community that's also involved. So it's an interesting dynamic, and I built this little set here that shows, and this actually shows my level of interest in this. Is I'm interested in what's going on in court, and I know this is a really emotional case, and these are real people. I want to be respectful to the families of the deceased and to all the real people involved, and not make this into some this team versus that team kind of thing, even though that's kind of what it is. I'm looking at it like I'm coming from the outside, and I've already seen like Lipstick Alley. There's a 228 page thread going back to 2019. They've been talking about this the whole time. And so I'm not looking to come in and just say this is what it is. For me, it's an exploration. So I've got this 800, 900 page transcript, and I want to go through all of it. And I want to go through all of it before the trial starts on the 2nd, and the second trial starts on the 7th. I want to have opportunity to understand like all of the detail, all the facts of the case, and all of I can see where the feelings are. The feelings is kind of what got me interested in the first place. I saw that there was like a class element struggle in the feelings, but then the feelings are also they're also colored by the fact that somebody died, an innocent child died, and so everything has to be taken with I have to understand that that's part of the feelings. And when I really think about it, if I consider it along the lines of, okay, the people feel that way because they really blame her for the death of the child, it's still kind of docile. I mean, they're not going as low and as dark as they could. So that makes me really, really wonder, like, what are the real details? I know that in court, they're going to present, what they can present in court. But I wonder what's the real story? A lot of people are really, really convinced that, that they did this. Now, from the outside looking in, my first impression, just looking at the detail, the overview, was that I don't think she did it, because I couldn't see what the motive would be, and I couldn't see how they can prove that she, beyond reasonable doubt, that she did this when the child was in the custody of several people during that same time period. And it all seems to rely on the medical examiners, making it a homicide. But up until before the medical examiner made it a homicide, the police didn't even consider it to be a homicide. And that also tells me something. So, well, listening to the other side about it, I had a certain impression. Then I watched a video. I need to link the video. I'll do that. When I do this for real, I'll link the video and put the video in the description. That gave another side that explained from the other side, and the side of the biological mother. And I heard some stuff in that made me see more detail. But then I also heard some stuff that sounded like there was some kind of class struggle between the different sides of the track, like between the church, the professional church side, which is where the stepmother was on, and then the other side where the biological mother was on. And it reminded me of that film. Um, I forget the name of the film. The film that what's it called? Eve's Bio. Similar to that dynamic, and it's like, oh, there is some kind of class struggle between these groups, because a lot of the comments about the stepmother were class based. They were kind of envy based. It's like they didn't like the fact that they were trying to be an upright family or something, and without having the other information, all you do, we just see, oh, that's the situation. But you start to listen to the other side, it becomes clear that there's way more detail than what was presented by that side. And the Lipstick Alley thread, 220 something pages, it's got a lot of detail. So I'm looking through the trial transcript, which was only available. I found it first available in a video format, and I finally found a space online where I can get a PDF of it. And the PDF is a photo PDF, which is disappointing. And so in the background, I've got this process that's doing an OCR converting it into text, so I can actually I can search through it. But for now, I just have to flip through the pages and look for content. The good thing about the transcript, though, is that the transcript has everything in it. Usually, when we watch a trial, we only see what it is that the jury hears. We don't really get to hear what they're talking about up at the judge's desk. But in the transcript, every single thing is present there. And the transcript is one of the things that also got me suspicious about the justice system in Mississippi, because the first thing that stood out to me in reading the transcript was that the judge told the jurors that they can't take notes, which I thought was odd. Turns out it wasn't so odd. That after some research, I found that like 35% of judges think that you shouldn't take notes for if you're in a jury. But along with not being able to take notes, the judge also said, even though the court reporter is taking a transcript of the entire proceedings, you also won't have access to the court reporter's notes, to the court reporter's transcripts. And so they're supposed to sit through the trial and keep everything in their heads. And that seemed to be a little odd, because I couldn't understand how. I looked at the capital murder statute in Mississippi, and I looked at the facts of this case, and I didn't see how the facts of this case matched capital murder in any way. And so I had to read through the transcript to see what the actual case said, because so far I was just listening to people talking about it. And so let's look at the actual case and look at what actually happened, and really let's look at the closing arguments, because if they're having to keep everything in their heads over all those days, and they don't have any access to anything that they wrote or any notes, and they don't have access to the transcript, most likely they're going to be swayed by what happens most recently before they deliberate. I also heard something about the verdict coming back quickly. So even though there's no evidence that she did it, it's all speculation, there are some oddities that I think would make people decide that you're guilty. For example, if you don't testify, if your husband doesn't testify, why don't you testify and tell us that you're innocent? Those are all things that contribute. And so I'm looking at all of these details, all these facts, and then I come across Okay, let me find out who the lawyers are. So, all lawyers are not created equal. We know that. So I wanted to see who is after I read the opening statement, I felt like the opening statement was so badly done. It was so badly done that, like, this must be an amateur, a new lawyer or something. And so I got the transcript and found the names of the lawyers, started looking up the lawyers, and I found that the primary lawyer is this guy, and he is a public defender. His name is Christopher Ruth. I'm not sure how to pronounce that. It's spelled like mouth with an R. And he's the primary. He did the opening and the closing. In fact, where's his opening statement? Right there. So in his opening statement, and I think I actually have an audio version of this that I made with some other voices, but just looking at the opening statement, he left so much out of what he was supposed to do with this opportunity to talk to the jury. And I could feel from watching from listening to the audio and from reading it that this was a really important like distinction for him to be involved in a death penalty case. I think that's a feather in your cap that you are a public defender and you have a death penalty case. You're saving people's lives. I think it means something to him. And you look at the opening statement, it feels like this was all about him. I think he forgot about the client completely. And what he wrote, it feels like he wrote it on the way to the courthouse. There's so much left out. I need to play an audio of this. I do this for real. And for example, this is the defense. Now, I had similar criticisms of the prosecution's opening. It was very, very weak. He kept mentioning evidence will show, but then he didn't have any evidence. It was all speculation. The only evidence in this case is the word of the medical examiner, right? Everything else is people just deciding something feels off. It's not evidence. So it's like, oh, that's a pretty weak opening. So let's see what the defense does. The defense starts out with Zakiya Bevily did not kill Jariah on October 22nd, 2017. Now, I thought that the first sentence was odd. I'm already criticizing. She did not hurt Jariah. She did not abuse Jariah. Now, these statements are already in dispute because this case is happening a couple years after the child is already, gone. And in this community, it's already been established that she was abusing her. Now, it doesn't matter if it's true. That's the reality of what's going on with this jury. Why was he even talking to this jury? How come this case wasn't moved to a different county? In fact, that's the first thing that the other attorney did just the other day. He's had it moved to a different county because there's no way she can receive a fair trial there. Now, I still think she's going to be found guilty because I think that the internet is in the other county also. And I think there's just been so much made of this. I don't know if there's any way to escape the judgment, that's already been pronounced out there on those streets. And so get back to this opening statement. Now, the story here Mr. Wallace has alluded to, Mr. Wallace is the, didn't do the opening, did he? Yeah. The story and the history is not a storybook. It's not a happy story theme from the outside looking in. Now, see, I think that that's a mistake also, because I think what he should be doing is he should be shouldn't be talking about what it looks like from the outside in. He should be trying to sell what it really was from their perspective. That this was a family that stayed together even though he had a child from an outside source, and they took the child in and cared for the child like it was their own child and maintained a relationship with the mother. Instead of him talking about any of that, he talked about it like it was disgraceful. So he says, Jerai was born from a one night stand just days before her father, Morris Bevily, married Takaya. That is a fatal mistake. It's disrespectful to the child, to the child's mother, to everyone who lost a child. It's almost like he's insulting the child. So the more I read the opening, I start to wonder, who is this guy? And this is before I knew what he looked like and everything. Like, who is this guy that's doing the actual opening? And in a situation where everybody is culturally in sync, to put it nicely, the district attorney is right there, assistant district attorney's there, the judge, he's on the new case. He wasn't involved actually. That's why his picture was like underneath that. This is everybody's of one cultural accord, and then we bring in this guy. And the reason it's relevant is that he seems to be completely out of sync with what's going on. He had any idea about the cultural implications of what's happening, he would have asked for a different county. And I don't know that he didn't. I still haven't found that yet. And he would have came out and he would have appealed to their sense of community. And he didn't. And so he didn't cast a positive light on his client in any way. He said darker things about them than the actual prosecution. And this opening is not evidence. He can say whatever he wants. And so I'm insulted by this. I'm not even involved. Jerai was born from a one night stand just days before her father, Morris Bevily, married Takaya. There were difficulties naturally. Were they really difficulties? Is that really accurate? Because if there really were difficulties, she would not allow the child in her house. Now that's a story that he could try to sell. When there's really difficulties between the wife and the baby mother, they don't take care of the child. But the fact that she's taking the child in and trying to have a relationship with the mother and trying to find some way to make it work, this betrays that there were difficulties naturally. But what you'll hear and what the evidence will show is that Takia, that in spite of all that, in spite of the hardship and the difficulty and the hurt and the betrayal, he did not have to put all that on top of that. Because this hardship, difficulty, hurt, and betrayal can be flipped into motive for murder. So why would you even say that? In spite of all that, Takaya loved Jerai. And just making the statement that she loved her instantly pissed everybody in the court off. I wasn't even there, and I already know that. That statement alone pissed everybody off. He's just there saying stuff that he thinks sounds good, but he has no idea about the cultural context. He has no idea how to read the room. He has no idea about what's really going on in that court, or he wouldn't have said any of that. He loved her like her daughter. She was her daughter. That made even the jury was pissed off when he said that. It's insulting. And instead of getting into the meat of it and trying to cast this in a different light, like, what is the basis of their family's idea that they should have a relationship, that they should take in the child that came from the other woman, even though everybody was single when the child was conceived. I didn't know that actually. And even though, if you're not single, you're married, and the child didn't come, out of some dirty situation, what's the basis for their thinking that we have to work together as a group? Where is the church in this? Where is the where's the spiritual part of any of this? This is a death penalty case. And so one of the first things that popped out to me was, I know someone in my own family that had this same situation. And in my family, the children are innocent. So even though the child came from an outside relationship, that's got nothing to do with the child. And so the child grew up in our family. No issue, worked in our businesses, went on to college and to lead a successful life. And the child considers all of us as family because we're all family. And the same thing that may have led this family to think that was the thing to do is what led my family to think that was the thing to do. And it goes back to the church. It goes back to her Christian roots. And the fact that he would never even factor in Christianity in this religious community is also, another hint that he's in over his head, and that he was culturally out of sync. I don't know why they didn't get money together and get them a lawyer. She would have been better off defending herself than having this guy. And when you finally get a chance to hear him speak, I have a clip of him speaking on a news station. He comes across as a liar. Now, I don't know him. I don't want to call him a liar, but he sounds like a liar. He sounds like the kind of liar that exaggerates points of magnitude. Like, I went to a party and there was 3,000 people there. Those kind of lies. And I can see that there's no way that he connected with that audience there. If anything, he may have made it worse. And then he goes on to say, now what happened to Jariah is a tragedy. What happened to her? No, what happened? He doesn't offer any alternative theory as to what happened, which is what you wanted to create. If you want to use for to create doubt, there's no alternative theory. He just says what happened to her was a tragedy. What happened though? Nobody knows what happened to her. You won't hear me or anyone deny that. Next page. What happened to Jariah was a tragedy. A young, vibrant life is no longer with us. No longer in the community, no longer in the family. He's again digging her hole, digging a grave for her. No pun intended. It's an undeniable tragedy. But that does not mean Takaya is guilty of making that happen. Doesn't mean that she's not guilty. I've seen some defense attorneys, when they really just have nothing, they have no ideas, they just go to this point about the rules. When juries don't really make decisions based on the rules. They can all vote to say that they think that she did it, and they really believe it. They'll just say that she did it. It doesn't matter if they violated the rules or not. So let's talk about some of the evidence that you're going to see. Now, this is what I don't like the most. You're going to hear evidence that Jariah was a normal, happy child. She was 14 months old. She was just learning to walk. She was happy-go-lucky. She was running around, learning to walk and falling. All those things that normal 14-month-old kids do. So on the morning of October 22nd, now October 23rd, when Takaya finds Jariah lifeless in her crib, the search for answers begins. These things do not even connect. He's just saying stuff at this point. You're going to hear how that search kept progressing. You're going to hear some evidence. You'll hear evidence presented, state about the investigators, how they came and looked and saw what happened and talked to witnesses. See, he's saying nothing. And the stuff that he laid out in this other sentence up here she was 14 months old, and she was just learning to walk, and it doesn't connect to anything. This whole opening statement was a waste of energy. He talks about evidence, but he doesn't present any evidence to the contrary. And when you look at the witness list, look at the actual case, there's something like, I think like 9 or 10 witnesses for the prosecution, and like 2 for the defense, and no character witnesses. Like, where's the pastor? Where's her mother? Where are the people that are on the other side to say, to at least talk about her character? Because most of this case comes down to, do you believe or not that she's capable of doing this? So her character is a really big part of that. If the other side has, the whole town against her, I think it's only right that the defense do their due diligence and bring in more people. And the reason I say this is not because I'm on the side of Takaya. I happen to believe that it has to be a fair fight in order for the victory to be real. So, Sixth Amendment, it gives everyone a right to a zealous defense for a reason. If, for example, if she had a better attorney for the first case, there wouldn't be a second case, because every single rock would have been turned over in the first case. Everything would have been brought up in the first case. They would have asked for a new venue in the first case. They would have vetted the jury better. They would have done everything better in the first case. And so, for better or worse, there would not be a second case. When you don't have a zealous representation, you open yourself to it being turned over on appeal. And we haven't even got to the appeal process yet, because it was likely that case was going to be turned over on appeal anyway, before being granted this new trial. And it has to be done. It's like if you were in a fight with a kid and you're fighting for reputation points, and he doesn't want to fight or doesn't know how to fight. Even if you win, you don't really get any points for that. So it's in the interest of justice to have the defense be on this job, and that they really go through all the possibilities so the jury can come to a real decision. So having a bad lawyer really just extends the process out. It's definitely going to be, you got to worry about, you can't rest. Even without the retrial, there was going to be an appeal. So I'm doing this on the system that I didn't have set up ahead of time for this. The system that I have set up for it is not this system. So I'm kind of doing this on the fly. This is just a walkthrough before I get to the real. Talks about the nature of the injuries. He doesn't offer any kind of alternative theory as to why it happened, as to what could have happened. Doesn't mention the father. He doesn't mention the chain of custody, that the child had been with other people, that the medical examiner's determination could be wrong. He just says a bunch of stuff in general. Going to hear the other side of the story. The state gets to go first. They get to tell you their story the way that they want you to hear it. All of this could not, none of this stuff has to be said the way they want you to hear it. But keep in mind, ladies and gentlemen, that half the story isn't the whole story. It is when you don't have notes. So that's what I'm asking you to do, is to listen to the whole story. This whole thing, I'm going to put a link to this in the description, is really that vacant. There's nothing in this that has any meat to it. He didn't convince anyone of anything. He didn't even make anyone wonder about what's going to happen in the trial. Like she's being just led to her execution. And it could be because he doesn't believe her himself. It could be just because he's just not a great attorney. It could also be that this case and what it signified to this attorney is connected to his own life. Because when I Googled him, what I found was that he was accused of the murder of a 23-month-old child himself. And he did a year in jail before he was finally acquitted. And he was only 14 at the time. But the reason we know about it and it's not sealed is because it was there's newspaper articles about it. They did a whole public relations push to get the word out, and he was found not guilty as a result. But his name is dirtied, which is probably why he's a public defender, because in private practice he wouldn't have a chance. And so having a lawyer that is associated also with the murder and molestation of a child, having that lawyer take the lead on your case it doesn't make any sense whatsoever. Into an all African American situation with African American dynamics going on that he's blind to. After this opening statement, she should have fired him. It would have been better for her to defend herself and just lay herself on the mercy of the people and just explain her side of the story than it would be to have this guy sanitizing everything, practice his speech in front of the mirror. Because whether or not he won this case, it's a win for him because he was arguing a death penalty case. Goes on his resume. He can check off another box. But it's her life. And the fact that they didn't testify, at least according to what I'm seeing, let me go back and look at that. Look at the witness list. I did not see either one of them. That means a lot that you didn't testify. It's either bad advice or indication of guilt. I just think of myself of all the alternative theories that they could have pushed forward, even if they were guilty. Think about what are all the alternative theories. In fact, that they didn't come up with any alternative. They didn't say, "Oh, I dropped her." No disrespect, rest in peace. They didn't say anything. Didn't offer any alternative stories as to how this happened, and that's kind of what leads me to think that they're innocent. Because usually when somebody is lying like that, the lie will adjust as the situation changes. But the fact that they didn't even come up with any other alternative theories as to maybe the child banged her head into the crib or something, or maybe the crib was too small, or there's so many things that they could have said that they didn't seem to say. And so, as an outsider who doesn't have all the information and who's still reading through everything, just going by the opening, I'm looking at the opening thinking, whoever the client is, even if I didn't know anything about the case, if I read this opening, I would say this person is going to lose because the attorney doesn't have a full vision for what they're trying to do. The attorney doesn't even believe in the case. They're not even trying to appeal to like the jury's sense of empathy, of humanity, of anything. They're just up there talking. If I read this, I would think that the defense attorney and the prosecutor are friends. They must live in the same neighborhood. They must have kids that go to the same school or something. This is definitely an alley-oop. It'll be interesting to see. I want to get my materials together because I got some video. Let me see if I can find it real quick. Nobody watching this anyway. Let me see. A quick mic pause. put a video up while I go find this clip.
What I emailed him and this and that to get away from the law, to have smoke and mirrors about the law. They agree that she can't get a fair trial. And they want to bring up a continuance. Her life is on the line. She has a 14th Amendment right to due process and equal protection. What I emailed him and this and that to get away from the law, to have smoke and mirrors about the law. They agree that she can't get a fair trial. And they want to bring up a continuance. Her life is on the line. She has a 14th Amendment right to due process and equal protection of the laws. And the Supreme Court is
arguing for the change of venue and like 4 or 5 motions. The main thing was a change of venue, and he actually won that. Let this play while I find this other clip I'm looking for.
very adamant that even if there was a continuance, her right to a fair trial outweighs having a firm trial date. That's the law.
The attorneys are the people who argue their motions from the court, but there shouldn't be any responses for anybody else sitting in the gallery of the courtroom. As far as the motion to change the venue, Mr. Sweet is correct. The law is what the law is, and this court follows what the law says. And so he has put on a prima facie case of what he has to do in accordance with the law by providing the affidavits, securing the signature of Ms. Bevily on the affidavit, and stating and proving to the court any evidence that he has on any prejudgment of this case in Clayton County. And the state, of course, has the option to rebut that, but has not done so, even though the court does recognize what the state has announced to the court regarding the timing of this particular issue. The court's reason for asking that question to Mr. Sweet at the time was because of the state's motion to sequester the jury. And the court would not have sequestered the jury had Mr. Sweet stated at that time that he wanted or desired a motion for a change of venue. But because of what the court has been given today, and since the last time we've been in court, and Mr. Sweet has made a prima facie case for a change of venue, the court is going to change venue. Now, what that means, though, is that the court date will not change. By the end of the day, the court will notify the attorneys where the change of venue will be, but I can tell you it will not be in Hinds County. But the court will notify the parties by the end of the day where the change of venue will be in Mississippi. So you can make sure that you let your witnesses know. Of course, there's probably nowhere in Mississippi out this case, but I would presume that the county that the court changes venue to, that county would not be as personally involved as Claiborne County and surrounding counties for this area of the state of Mississippi. And although they may have heard, they may not be as intently watching. But I believe that more dire in another county, the attorneys will be able to choose and select and agree on 12 jurors that are impartial and unbiased. So the motion for change of venue is granted. Thank you, Mr. Sweet. Give Dr. 3 and 4. You have a third motion to compel production.
That ended abruptly. That was just change of venue clip, which I'm trying to clean up. the filming of this is being done by a third party, so it's not always at the optimal angle and everything. But we appreciate it, and the audio is it's boomy, so gotta clean up the audio, and video is not really so important in this case. It's just a matter of keeping track of the details because it's not being tracked nationally. If this case gets any national attention, then it could be, broadcast. But I don't think it's going to get any national attention. It's just going to be that one journalist giving this video, and we just have to make do with what we get. It's really interesting listening to the arguments though, and just how informal the court is, how informal the prosecutor is. I don't know how else to say it. It just seems like it's really, really small town. It's got a small town feeling to it. They don't even show any real respect to the court. It's got a family feeling to it, which is scary in a death penalty case. I tell you that cold hard procedure could be a comfort when it comes to something as serious as your whole life. Just listening to the arguments, listening to the way they talk to the judge and the logic of the arguments. I'm like, are these legal arguments or is this like passion court? But even just in this pretrial motion hearing, this lawyer is 3,000 times better than the lawyer she had in the first trial. So I don't feel like this lawyer is a criminal lawyer. I looked at his website, I looked at what he, highlights in his own career. He's talking about how much money he won for his clients. And so he seems to be a civil lawyer, civil rights focused, civil suit focused. This is a death penalty case. This is a case that needs a specialized lawyer that specializes in criminal defense. The arguments that in the way he argues in the pretrial makes me worried even more that this whole thing will be turned over in appeal. It'll just be extended that much longer. Because that's the formula. It seems like having a weak lawyer on the defense side when you think the person is guilty is good, when actually the opposite is true. Better to have a strong lawyer on the defense side when the person is guilty. Then when they're convicted, they're going to stay in jail. Because every single, option has been tried. Every rock has been turned over. All due diligence has been done. So this one seems like it's more on a better track than that last one, and they have the whole trial transcript from the last one to use, and I'm confident this time she's going to testify. Because again, this wasn't an appeal. This wasn't sent back by an appellate court. This is a retrial. This is a whole new trial. So I expect to see witnesses. I expect to see pastors. I expect to see church members. I expect to see a whole different vibe. I expect to hear in the opening statement some reference to spirituality, to their Christian something, their goodwill, their attempt to try to have this relationship instead of shunning the child completely, being embraced by the whole family instead of, it has to be more of in this vein. So I'm not sure if they're going to allow cameras in, because if the jury is being sequestered and the venue is being changed, are they going to allow cameras in the courtroom? Probably not. And so how are we going to get information about what's going on is going to be through what? Interesting note. I know I'm rambling. Interesting note is that Mississippi just recently they're converting all the counties over to electronic system, MEC, but they clearly don't want to do it. They clearly don't want to do it, and they've got the biggest paywall in the world in front of their information system. You don't pay by, it's not like Pacer, right, where you pay by what you decide to download. No, in Mississippi system, you pay 20 cents a page, whatever comes back from the search that you entered. It doesn't matter if you download it or anything. If you get search results, you're paying for the search results by the page. And if your search results return nothing, you still pay for the cost of one page. That's a paywall, and that's designed to keep you from digging into their business. Because if you're trying to find any information about what goes on in Mississippi courts, good luck. Really difficult. You know, my first impulse is I want to see everything that the judge ruled on in the last year, you know, in similar cases. I want to look at similar cases. I want to see how this stuff is handled. There was one person being interviewed. I think she had red hair or pink hair. She was saying that they had never had a case reversed in that courthouse in recent history. That the fact that this case is being retried is evidence of some kind of conspiracy by the judge. I don't think that, you know, legally that's not really a legal argument, because if the juror was related to, you know, to the victim, that definitely is cause to retry the whole case. But to think that every single juror said guilty last time with no notes, no trial transcript, all circumstantial evidence other than the medical examiner. I'm going to go look at that stuff right now and get a clearer view. Medical examiner's information. You can't really rely, at least I haven't been able to rely on either of the two camps for information, because it's all so impassioned and it's all so, you know, biased toward their side. It's hard to get anything clear. And then getting information from the court is just difficult. I had to jump through a bunch of hoops just to get that transcript. But I hope to go live for the trial in May, and I hope to have some organized lives around this, going through the previous case, opening statements, then going through the witness statements, and then going through the medical examiner. The medical information is the most important part, because I think it's the only evidence, and then closing arguments. So I want to make at least 5 different shows between now and May 2nd. But I'm going to prepare the shows ahead of time, and I'm just going to premiere them. It won't be live stream. This is really just to get a feel for this, see how my set works on here, and also seeing if I can stream 3 lives at one time. I got 2 going right now on the same channel. Well, anyway, that's enough talking for me.
What I emailed him and this and that to get away from the law, to have smoke and mirrors about the law. They agree that she can't get a fair trial. And they want to bring up a continuance. Her life is on the line. She has a 14th Amendment right to due process and equal protection of the laws. And the Supreme Court is very adamant that even if there was a continuance, her right to a fair trial outweighs having a firm trial date. That's the law.
The attorneys are the people who argue their motions in front of the courts, but there shouldn't be any responses for anybody else sitting in the gallery of the courtroom. As far as the motion to change the venue, Mr. Sweet is correct. The law is what the law is, and this court follows what the law says. And so he has put on a prima facie case of what he has to do in accordance with the law by providing the affidavits, securing the signature of Ms. Bevily on the affidavit, and stating and proving to the court any evidence that he has on any prejudgment of this case in Clayton County. And the state, of course, has the option to rebut that, but has not done so, even though the court does recognize what the state has announced to the court regarding the timing of this particular issue. The court's reason for asking that question to Mr. Sweet at the time was because of the state's motion to sequester the jury. And the court would not have sequestered the jury had Mr. Sweet stated at that time that he wanted or desired a motion for a change of venue. But because of what the court has been given today, and since the last time we were in court, and Mr. Sweet has made a prima facie case for a change of venue, the court is going to change venue. Now, what that means, though, is that the court date will not change. By the end of the day, the court will notify the attorneys where the change of venue will be, but I can tell you it will not be in Hinds County. But the court will notify the parties by the end of the day where the change of venue will be in Mississippi. So you can make sure that you let your witnesses know. Of course, there's probably nowhere in the state of Mississippi that has not heard about this case, but I would presume that the county that the court changed venue to, that county would not be as personally involved as Claiborne County and surrounding counties for this area of the state of Mississippi. And although they may have heard, they may not be as intently watching. But I believe that Morri in another county, the attorneys will be able to choose and select and agree on 12 jurors that are impartial and unbiased. So the motion for change of venue is granted. Thank you, Mr. Sweet. Giving to Dr. Green Ford, you have a third motion to compel production.
Yeah, I'm still hanging around. Now, this is her attorney. Of course, he was 14. The only reason I know about it is that they made an article about it. Otherwise, it would have been sealed. So you can see he was he was charged with. In fact, this is the beginning, right? How clear is that on a telephone? I wonder. I might need to cut this in half. Show it in the center of the screen for cell phones. Charges were murder and aggravated sexual molestation. And this is of a 23-month-old child. Spent a year in jail, and he was ultimately acquitted. So he was found not guilty. But they spent $400,000 in expenses, and the fact that there's even an article like this, I mean, think about that. Why would you even out your kid like that? This is all a public affairs, campaign. You know, juvenile records are sealed. When you search his information, this is one of the only things that comes up. So, and it's really trying really hard. The polite teen, the polite teen had often babysat. He was the person that was in possession of the child. He was the person that called 911. And when they did the check of the child, they found the child had been molested. And obviously they had enough information, enough evidence to arrest him. But again, we got to keep saying he was acquitted. My point is not to retry his case. My point is to ask, why would you hire this guy as your lawyer in a case about the death of a child? That has got to be, I mean, and he's a public defender, so he's not the only public defender. There's other public defenders. Why him? It's a question I would also ask to him is, why would you insert yourself into a case about the death of a child when you yourself was accused of the same thing? Your name is still dirty because you were acquitted, but everybody doesn't think that you're innocent. Why allow your story to be added together with her story? The more I look into this case, the more strange things like this keep coming up. This is a very strange case. I never would have thought that. When a person does something when they're, you know, juvenile, you never know about that as an adult. And it looks like dad was of that opinion. Like, why are we doing this? This is definitely his mom's idea. They're trying to clear their family name. He doesn't seem to want to do it either. And the way the article is written halfway feels like trolling. If I could, push trolling back into the past. Where is it? This I mean, this, for example, to me, the reflection, duality, I feel like that's a criticism. Stretch that so we can see it. Stretch the screen. Oh, that's crazy. That's not what I wanted. I have a PDF of this. Do this on here. So to reset, to transform completely. There we go. So left, she was running around playing, bouncing the ball through the field. That's the father. Ringo, Christopher. She died 2 days later. Okay. There were vaginal tears consistent with sexual abuse, according to the autopsy. And me's putting people in jail for real. Found swelling in the brain consistent with shaking baby syndrome. Three 360 days in lockup. Differentiate himself. He met teens who bragged about manufacturing methamphetamines. All right, bro. He rallied around him to persuade a judge to allow house arrest. Dream lists of witnesses lined up to testify about his outstanding character. Now, this is further to my point. So even in his case, the way he got off was based on his character because the evidence pointed to him as as the person. But they rebut that by having the whole community rally around him and come line up and tell the judge how great a person he was. I'm not sure if he asked for a bench trial or if this was a jury trial or what. Yeah, I know I can look. Well, I can't look it up because he was 14. Church's youth minister. This is all the same stuff that you would think he would be doing in this case his with his client, because he himself was charged with something similar and he saw what they did to get him off. Says jury, so it was done by jury. Okay. Jury of 6 men, 6 women deliberated for 6 hours. What does that mean? 6 hour deliberation. So I'm quite sure there's people who think that he did that. His family spent 400 grand. I'm sure he had great lawyers. So even us just looking at it, from Google, is suspicious. And this is definitely not the lawyer that you want to represent you in a child murder case. That is definitely a criticism. I don't care. They didn't catch it. The photographer is trolling. That's duality. They don't believe him. I'm not surprised he's not there on the retrial. Hopefully he's not. I did some research on each of the people on that wall back there. Found nothing. It's interesting that everybody calls him Sweet. That this attorney is like locally known for civil trials, and he's passionate about whatever he's talking about. He cares about the person that he's defending. It seems like that's definitely a plus. And it would be great to have a different judge too. He can find a way to get the judge to recuse herself. And it's only because, just from what I read, I didn't see that the judge was doing anything wrong, but I think it's in the judge's interest for the case to, you know, go the same way. I think to me, it's a conflict of interest to have a retrial with the same judge, even though it's the judge that that made this happen. Not really. I mean, it's the attorney that made it happen, but I feel like the judge has a vested interest in this not going a different direction, and it'd be better just to give it to a different judge. Anyway, I'm gonna get the rest of my materials together and get ready for a real presentation. It'll just be a premiere, get everything lined up the way I want, and then we'll do a call-in show, get information from other people because again, this is an exploration. This is not like an expert show. I'm not an expert telling people, how things are supposed to be, and no, this is just looking and wondering and talking, asking questions, looking for answers. It's all exploration, and I have a rule that I quote to people that if you don't have a dog in the fight, you don't really care, if it's not a big deal to you, then you should never be in an argument with someone who does have a dog in the fight and who does care, because you're unequally yoked. So my level of discussion is not, I'm not looking to lock horns with people that are you know that this is really a huge thing in their personal life. I think that those people should regard the trigger warning that'll be on this show and just keep it moving, because if this is your real life, this is happening to you locally, you might not need this virtual stress when you got the real stress coming up, in a couple weeks. So for the rest of us out here just looking from the outside and trying to understand all the pieces, this is what this space is for, just to explore. And I want to explore in a detailed way. This podcast is called Zooming In on Every Blade of Grass because it's speaking to just how slowly we go through everything. Just the level of detail and just taking the time to try to understand all of the elements and not rushing to some conversationally expedient conclusion just because. Well, anyway, that's it. That's enough. Let me get back to my Johnny Depp show. And yes, you can run up to 4 live streams on the same channel at the same time. Peace out.